Right, well, let's begin. Good afternoon, everyone. Thank you very much for joining us today. My name is Oliver Lewis, and I'm a barrister at Doughty Street Chambers. I'm joined today by two of my esteemed colleagues, Alice Irving and Sarah Steinhardt, who I will introduce in a moment. This is the latest in our series of Equality Act webinars, and there are two more to go, details of which you can find on our events page. So Sarah, Alice and I have designed this particular webinar to be community facing, and by that what we mean is that we've designed it for disabled people and their representative organisations. And so while we realise that there are some legally qualified people joining us today, and of course everyone is very welcome, this webinar will be pitched at people with no legal qualifications to try and demystify some of the law and increase legal literacy, for want of a better phrase, for disabled people who may be facing discrimination or may want to know more about what discrimination actually is and how they can initiate cases and so on. So having said that, everyone, of course, is very welcome. Another thing I wanted to say at the outset is that, unfortunately, while we will have a question and answer session towards the end, we won't be able to give advice on individual cases. So if you'd like us to speak about something, just please keep your question general rather than specifying anyone's particular problematic situation. So I am going to move on to begin. The webinar is divided into three short presentations, and we're barristers, so we're desperately aware that we can drone on and on and on, no problem at all, but we've been very strict with ourselves, and I'm going to speak for a maximum of 10 minutes, and Alice and Sarah are going to speak for 15 to 20 minutes each. I'm going to be speaking about discrimination in general. I'm going to be looking at international law, focusing on the European Convention on Human Rights and the UN Convention on the Rights of Persons with Disabilities, and explain what the Equality Act says about disability. And then from there, Alice is going to then explain the different types of discrimination and the different causes of action, what people can do about discrimination or claims, or what people can do if they feel that they've been discriminated against in different areas of life, and what the law can do about that. And then Sarah is then going to be giving some examples of how these cases can be run. How do you take a discrimination claim? Which courts do you take that in? And what are some of the practical elements of doing so? Good. So next slide, please. And I think Sarah has the PowerPoint trigger. So let's look at what discrimination is. So, of course, one of the myths is that discrimination simply is something bad that happens to me. And I can say that, oh, I've been discriminated against. Well, in general terms, of course, that's perfectly fine to use the word discrimination in that way. But the law, both international law and English and Welsh law, I think roughly there are three elements to discrimination. One is that someone's been treated in a different way from others, and that differential treatment has some kind of negative impact on the person. It's bad, or it's prejudicial, or it's of detriment to them, and that bad treatment is somehow connected to something about the person, because they're a disabled person, or because they're a woman, or because they're black, or whatever the term we use is protected characteristic. So that roughly those are the three elements of discrimination. Next slide, please, Sarah. Thank you. And you might have heard that discrimination, or the right to non-discrimination, is, sorry, yes, Alice has just said in the chat there, please put any questions that you have in the Q&A button at the bottom. Apologies for forgetting to mention that. So you may have heard that the European Convention on Human Rights, which is embedded in the UK via the Human Rights Act, contains a right to non-discrimination, and that's in Article 14 of the Convention. And you'll notice there, and I'm not going to read it out, that there's a big list of protected characteristics, but it doesn't say disability. And we have to remember that the convention was drafted in the 1940s and it was adopted in 1950. And since then, quite recently, in fact, in 2009, the European Court of Human Rights confirmed that disability can be read into other status. So effectively, the European Convention, Article 14, protects against disability based discrimination. But Article 14 is what we call a parasitic right. It has to connect with or attach onto another convention provision. It's not yet a freestanding right. So you have to attach it to something else, some other substantive right that you're saying has been breached. Thank you, Sarah. Much more relevant and perhaps more interesting is the 2006 UN Convention on the Rights of Persons with Disabilities, the CRPD, which the UK government ratified in 2009. And the CRPD in Article 5 sets out a comprehensive prohibition on discrimination, and it sets out duties on government. So the UK government has to, under the CRPD, ensure that everyone is treated equally under the law and are entitled to equal benefit of the law without discrimination. And it sets out an obligation on the state to prohibit discrimination in all its in all of its different types, and it goes on to specify that a failure to provide reasonable accommodation, which we'll come on to in a minute, constitutes discrimination, unlawful discrimination. So Article 5 sets out the prohibition. Next slide, please. And Article 2 sets out some of the definitions. So the CRPD says that discrimination on the basis of disability, which is the catchphrase that this convention uses, means a difference, so a distinction, exclusion, or restriction on the basis of disability, which has the purpose or effect of impairing, nullifying the recognition, enjoyment, or exercise on an equal basis of a human right. That's really a big mouthful. And I just want to pick out there, highlight that the the distinction, the differential treatment has to have the purpose or effect. And Alice will explain further, I think, because this is going to be relevant to the distinction between direct and indirect discrimination. But for now, it's important for me to flag that you can be successful in a discrimination claim even if the person doing or organization doing the discrimination, the discriminator, doesn't intend to discriminate against you, but the effect of the treatment is that you're discriminated against. So that's important. And it also specifies here that the denial of reasonable accommodation constitutes discrimination. So let's see what the definition of reasonable accommodation is. And the convention says that this is the necessary and appropriate modification and adjustment, not imposing a disproportionate or undue burden where needed in a particular case to ensure persons with disabilities the enjoyment of all of their rights on an equal basis with others. So important here to flag that this is in a particular case. So the reasonable adjustment is in relation to an individual and that person's particular circumstances. Next slide, please. And so just to clarify, another confusing element of the convention is that in Article 9 of the CRPD, it sets out provisions on accessibility, which is often confused with reasonable accommodation. But in the CRPD, Article 9 is the anticipatory duty. Article 9 doesn't set out a right to live in an accessible environment. It sets out a duty on governments to ensure that the physical environment, transportation, information and communications, etc., are made accessible. So it applies to groups. So there's a duty on the state to anticipate that, hey, in any particular society, there'll be some blind people and visually impaired people. There'll be some autistic people. There'll be some deaf people and those who are hard of hearing. And how do we organize our transportation system to make it accessible to inevitable people who are blind or deaf or who are autistic and so on. Whereas reasonable accommodation is based on individual requests and has to be tailored to an individual person's needs. And it's a failure to provide reasonable accommodation which constitutes discrimination. So you can see more in a very interesting report or general comment published by the UN Committee on the Rights of Persons with Disabilities in 2018. Thank you, Sarah. So moving on to the Equality Act, which is what this webinar is going to be focused on. The Equality Act doesn't say very much about disability. In a sense, it says that a person has a disability if they have a physical or mental impairment, and that the impairment has a substantial and long-term effect on the person's ability to carry out normal day-to-day activities. And then there is supplemental guidance which the government produced, which fleshes out that test, it says, has 4 elements. That the person must have an impairment that's either physical or mental, and that's what the Act says. That the impairment must have adverse effects which are substantial, serious, significant, that those adverse effects must be long-term, and that phrase long-term is also used in the UN Convention on the Rights of Persons with Disabilities, and that the long-term substantial effects must be effects on normal day-to-day activities. There is a lot more that the statutory guidance and subsequent case law says about the definition of disability, but in a nutshell, that's what we wanted to tell you about. I'm going to hand over now to Alice, who's going to tell you about the forms of discrimination. Thank you.
Fantastic, thank you, Oliver. So I'm going to be going through the types of discrimination that are prohibited or are not allowed under the Equality Act 2010. That's the main piece of legislation in the UK that you're likely to be using if you're challenging, say, a school or a landlord or some other body for conduct you think is discriminatory. You'll see on this slide that there are 6 types of discrimination, and this can seem sometimes quite confusing and technical, and often they overlap. I'm not going to have time to talk about harassment and victimization specifically because there's a lot to cover, but just be aware that those are also things that are covered by the Equality Act. So I'm going to start with just direct discrimination. Sarah, if I could have the next slide, thank you. So this is the most straightforward type of discrimination, and this is where a person is treated less favorably. So they're treated poorly and they're treated badly in a way that's different to, say, someone else, and that's because of their disability. So for example, a school might refuse to admit a student because they are disabled, and if you can show that the reason they've done the thing that is the bad treatment is because of the disability, that's direct discrimination. And if you can prove that, there's no defense available in law to somebody who's done that. And so that would be the beginning and the end of the story. That would be discrimination, which was unlawful. There's an important extra little point in the Equality Act, which provides that somebody can't argue the other way around. So a non-disabled person can't say, hey, that disabled person's being treated better than me, therefore I'm being discriminated against. The Equality Act says that that's not discrimination because they recognise that disabled people might have greater needs that need to be met, and that they might need to have better treatment than a non-disabled person, and people are allowed to do that without that being a problem. So let's move on to some of the more perhaps complicated, but the more common forms of discrimination. It's quite often difficult to prove that somebody has directly discriminated, because they'll often say, no, the reason I treated that person in that way is not because of their disability, it's for this other reason. And that's where things like indirect discrimination come in. Now, I've got up on the slide sort of the breakdown of the technical aspects of that. But before I go into that in detail, I think it's useful to think of indirect discrimination by using a really simple example. So, for example, you might have a rule or a practice that somebody adopts that looks like it treats everybody the same. But when you apply it, it actually disadvantages some people more than others. So, for example, say if the fire service said you have to be above 6 foot in order to be a fireman or a firewoman, clearly that means that less women are going to qualify, because women are generally shorter than men. And so you say, well, that rule looks like it treats everybody the same, but it actually disadvantages women. And so in that way, we might say it discriminates against women. So this is the kind of thing we're talking about when we're talking about indirect discrimination. So the first thing under the Equality Act that you're looking for is what they call a provision, criterion, or practice. And sometimes you'll hear people refer to this in short as a PCP. That just means you have something like a rule or a policy or a way of doing things that's applied to everyone, whether they're disabled or not disabled. So my example of the fireman, you've got a rule about height that's applied to everyone. It might be a practice, and I'll use an example later when I apply this to give another explanation of what that means. The next thing you need to show is that that PCP, or that rule or that practice, puts people with a disability at a disadvantage when compared with non-disabled people. So you have to look at, well, what does that rule do? How does it apply to a disabled person? Does that put them in a worse position when compared with non-disabled people generally? And we don't just look necessarily at all disabled people, we'd be looking at people with the kind of disability, same kind of disability as the person in the case you're concerned with. And again, I'm going to provide an example, so hopefully that will be clearer. And then a slightly different question, slightly different. So you've looked at, does this rule, generally speaking, disadvantage disabled people? And then you have to show, well, does it disadvantage this particular disabled person who's wanting to make a complaint? So you've got to show general disadvantage and then disadvantage to this particular person. If I could have the next slide, please, Sarah. So I've got an example here. So an example might be that a school has a policy or a practice of handing out detentions to students who leave class without asking for permission. So that's the general rule or practice that's applied to everyone. That looks like it applies to everyone equally, and so what's the problem? Well, here, for example, say John is autistic, and sometimes he has to leave class quickly because he gets overwhelmed by the noise, and that's part of his autism. And the school gives John detentions when he leaves class without first getting permission, because they've applied this rule that they apply to everyone to him. So if we break that down into the bits of indirect discrimination I've just set out, first of all, the school has a policy or practice, and that is giving detentions for leaving class without permission. They apply that to everyone. That practice puts autistic people at a disadvantage when compared to non-autistic people, because they're more likely to need to leave class without having time to seek permission. So you look at the rule and you say, well, why does it disadvantage that people of this type of disability more than people who are not disabled? And in this case, it puts John in particular at a disadvantage because he often has to leave class without seeking permission, and as a result, he's getting detention. So he's personally affected. Next slide, please, Sarah. So on the face of it, that looks like indirect discrimination. But there's something really important to remember about indirect discrimination, and that is that there is a potential defence. And again, this uses slightly technical legal language. Effectively, a defendant, so here the school, would have a defence if they could show that the provision, criterion, or practice, so that rule about giving detentions, is what they call a proportionate means of achieving a legitimate aim. And you've probably heard that language battered around before. So let's break down what that means. First of all, the school has to have a legitimate aim. So what that means is that the rule or the practice they're adopting, they have to have a reason for that. And that reason has to be a good reason. It can't just be, well, we just want to have a rule, so leave us alone. The second part of that is that the rule itself has to be what they call a proportionate means of achieving that aim. So they're trying to achieve something, they need to show that effectively they couldn't really achieve what they want to achieve by doing something that would be less impactful on disabled people. Now, let me apply this again to the example. If I could have the next slide, please, Sarah, to hopefully help. So here, I imagine that the school would say, well, the rule they have, the aim is that they want to ensure class attendance and they want to maintain discipline at school so that kids aren't coming and going out of the classroom whenever they want. Those sound like pretty reasonable goals to me. So those would be the legitimate aims. The next question is, well, is it proportionate to apply that rule to everybody, and in particular to apply it to John? And we might rephrase that question by saying, well, could the school achieve their aims, for example, by doing something different? So could they still uphold discipline at school and maintain attendance by having a more flexible rule? So I think, for example, you might say, well, for someone like John, they should be able to allow him to use a timeout card that indicates he needs to leave the classroom without having to ask for formal permission, and that he shouldn't get a detention, and that it's not necessary for the school to ensure attendance and to maintain discipline to be so hard on John and to apply the rule strictly to him. So that's the kind of argument you would have about the language of proportionality. It's useful to know that there are various guides online, say in relation to education or different contexts, which give examples about what is proportionate and what isn't. And maybe when we put these slides on the internet later, I might provide some links to those slides. But it's always going to depend a lot on the particular facts of the case, and effectively whether you can say, well, you could have got the outcome you wanted without doing this particularly harsh thing or this thing that's bad for this disabled person. If you can argue that, you can probably show that they couldn't justify their conduct, and this is still unlawful discrimination. Okay, so the next form of discrimination under the Equality Act seems very similar, and it's discrimination arising from disability. And there is a lot of overlap with indirect discrimination here, but the main difference is this. Do you remember that when I set out indirect discrimination, I said that one of the steps you had to show that the rule or the practice impacted on disabled people generally in a way that was bad when you compared them to non-disabled people. So there was this kind of comparative exercise between disabled and non-disabled people. There's nothing like that in relation to discrimination arising from disability. You don't need to carry out any comparison with a non-disabled person. All you need to show is that a disabled person is treated unfavorably, so they've had some kind of detrimental or bad treatment. And this is the kind of important part because of something arising in consequence of their disability. So that means they've been treated in a way that's bad or for them because of something, and that something is linked to their disability. So you need to show a connection in terms of the disability and the thing that's being responded to. And perhaps again, an example is the easiest way to show that. So if I could have the next slide. So again, we're back with John. So we can say, okay, well, he's being treated badly or unfavorably, he's been given a detention. He's been given a detention because he has to leave the class without asking permission. And that, the fact that he has to leave the class without asking permission is because he's autistic. So you can see the connection here. You can see he's been treated badly because of something, the something being that he needs to leave class, arising out of his disability. He has to leave class because of his disability. So that would be discrimination arising from disability. Let me give you another example in a different context. So imagine someone called Jane, who has a disability. She has a chronic mental health condition. Because of this, she doesn't manage her money and she fails to pay her rent, and then her landlord tries to evict her. Here again, she's being treated unfavorably. The landlord is trying to evict her because of something. So in this case, because she hasn't paid her rent, and that something arises in consequence of her disability. That is, she's unable to pay her rent because her mental health conditions mean she isn't able to manage her money. So I hope that that helps flesh that out and explain a little bit more about what discrimination arising from disability means. If I could have the next slide, please. Again, like indirect discrimination, it's possible to have a defense to this if you can show that you had a legitimate aim and that the way you acted was proportionate for achieving that legitimate aim. So let's look at the example of Jane with her landlord. Landlord might say, well, my aim is to ensure that my tenant pays rent, and I need to have the rent in order to, say, pay my own bills. And we would say that's a reasonable aim. They can expect to be paid their rent. The question then is whether or not it's proportionate to try to evict Jane, given her mental health condition. And the answer to that is going to depend a lot on the circumstances. For example, how much rent is owing. If there's just a little bit of rent owing and Jane's back on track and paying, you might quite easily be able to say, well, it's more than you need to do, landlord, to ensure that rent is paid to evict Jane. You're just doing more than you need to, and so you can't justify this. On the other hand, if a lot of money is owing, it might be quite difficult to argue that the landlord isn't able to do this. Other things to consider might be whether Jane has had any support provided to her. Again, if the landlord goes straight to eviction without thinking, well, Jane has a mental health condition, maybe if she had some help, she could manage her finances and pay her rent. Maybe then you could say to the landlord, no, you can't justify kicking her out yet, that would be disproportionate. So these are the kind of factual matters that will come into play, and it's all going to depend a lot on the circumstances. Next slide, please. So the final form of discrimination I want to cover is a failure to make reasonable adjustments. Now, Sarah's going to cover a bit more about the different kind of settings in which the Equality Act applies, whether that be in schools, as I say, in relation to property and tenancies. I'm an education lawyer and a housing lawyer, so these are the examples I like to use. But there are other settings as well. For example, if you are accessing services, if you go to a shop and ask for something and the way they treat you, that might be covered by the Equality Act. But basically, the Equality Act says when particular people owe a duty to make reasonable adjustments. And it's set out there, and I think hopefully Sarah will cover that. Where they do owe that duty, it basically means that if they have a rule or practice that disadvantages disabled people, or if they have, say, physical features in the building that disadvantages disabled people, they should make a reasonable adjustment. Similarly, if they could provide an aid to a disabled person to prevent them from suffering substantial disadvantage, they should be provided with that aid. So, for example, if a university could provide a person who uses a wheelchair with a wheelchair accessible desk, which allows them to access class in the same way as their non-disabled peers, that would be a kind of an example of reasonable adjustment where you're providing what they call an auxiliary aid. Now, you'll see the language in the legislation is that it needs to be a reasonable adjustment to prevent a substantial disadvantage. And if I could have the next slide, Sarah. I think that's kind of misleading, because actually the Equality Act elsewhere defines substantial to mean actually just more than minor or trivial. So you just need to be disadvantaged in a way that's more than minor, or something that's just not, small. It doesn't need to be a massive disadvantage for this duty to make reasonable adjustments to kick in. A really important part of this is this idea of what's reasonable, a reasonable adjustment. So you might say, well, it's reasonable to expect, for example, a university to have wheelchair accessible desks, but you might say that it's not reasonable to expect them to provide a whole bunch of state-of-the-art, really expensive equipment. And it's all going to be very, very fact-specific. To be honest, most of the time, people are only asking for things that are very reasonable, and they're not being provided, as I'm sure many of you perhaps have unfortunately experienced. But some of the arguments that we've sort of had about, well, is it the right thing to do? Can I justify kicking this person out or not? Is the same kind of argument you would have about a reasonable adjustment. Is this something you can expect a person to do to accommodate the needs of a disabled person, to make things more fair and equal for them, or is it really too much to ask effectively? The duty varies a bit depending on context, and that's quite technical, and I'm just going to leave that there, but it's worth noting that particularly in the housing context, it can be a bit more limited in that you might not be able to, for example, insist that a landlord change features in a flat. So, for example, install a chairlift using the Equality Act. It's going to be a different kind of question. If I could have the next slide. Oh, perhaps we've got some unnecessary duplication there. My mistakes. Can we have the next slide, please, Sarah? So again, the kind of examples I used before, and this is where you can see the overlap between the different concepts of discrimination coming in. A reasonable adjustment to the school policy. So before we had the policy or the rule saying you have to ask for permission to leave class, a reasonable adjustment to that policy might be to say that for autistic children, they can use timeout cards instead. Other reasonable adjustments in the education setting might be providing screen readable documents to students who need to have accessible formats. All of these are really reasonable things to ask for. And as I say, in my experience, disabled people generally aren't asking for anything that's unreasonable. The most important thing as well to note is that you should never be charged for any of these reasonable adjustments. So for example, if a school were to say, well, yes, we can provide readable, PDF readable, examples of school worksheets to this person, but you have to pay because it's going to cost us to convert the documents or to make the documents accessible. They're not allowed to do that. That would be unlawful. You don't have to pay for any reasonable adjustments that are made. Now, I know that's quite a lot and that's a whirlwind tour. I do see that Oliver has usefully put into the chat box a bunch of those guides that I referred to earlier, that also, some of that's quite technical, but they also provide quite useful examples and example boxes. So we've got some codes of guidance there about the application of the Equality Act in relation to, say, shops selling services, or a local authority exercising their functions and offering services, or in the employment context. And there are also similar documents in relation to schools and so forth available online, which have some useful examples. I'm mindful of time. And so I will now hand over to Sarah to cover the remainder of the kind of practical aspects of potentially bringing a claim.
Thank you very much, Alice. So I can see that there are lots of questions. So I'm going to try and race through a little bit so that we have plenty of time to address those. I'm focusing on how to turn your complaint into a claim. So I'm looking at perhaps the slightly more technical aspects about how you actually formulate these issues to turn them into a claim. And if I can start with the sort of the basic scheme of the Equality Act, essentially, there are three things which need to coincide in order for you to have a claim. And those are the protected characteristic, which in this case is disability, that's what we're talking about. The unlawful behaviour, the unlawful act, or the discrimination. And the reason why I'm saying both is that victimisation is not technically discrimination, harassment is not technically discrimination, but nonetheless it's treated in exactly the same way. And the third thing that needs to coincide is the sphere of activity. So the area of life which is being dealt with. And that's because you can't bring a claim of discrimination against, for example, your neighbour who is being abusive towards you, because there is no basis for liability between private individuals. So first of all, I'm going to talk about what it means to be a disabled person. And Oliver has addressed this briefly, but I want to explain a little bit about why it's important and how that relates to different sorts of claims. So there are some circumstances in which a non-disabled person can bring a claim for disability discrimination. And I'll explain why that's important. And that tells us who needs to be the claimant. So the very first thing, if you're contemplating a claim, is, well, who is the claimant? So section 13 is direct discrimination, which Alice spoke about. And that doesn't require the claimant to be a disabled person. So that is because of a protected characteristic, not necessarily the claimant's protected characteristic. So to give an example, a woman, we'll call her Fiona. Fiona applies for a job and she lets slip that she has a disabled child. And she doesn't get given the job because her potential employers assume that she's going to need to take time off, and they make all sorts of assumptions about her. Well, that might well be direct discrimination because of disability, not her disability, but a disability. It's very rare for direct discrimination to apply in a disability case, because in most cases, it's going to be the effects of the disability which are giving rise to the discrimination. But where it does work is where there is assumptions which are being made, for example, where it's not an actual effect of a disability, but it's the assumed effects of the disability which are giving cause for the discrimination. Section 26 is harassment. For example, in this situation, Fiona is having trouble with her neighbours. So her neighbours have made some complaints about the behaviour of her son. And it's not really very fair complaints which are being made. But when the housing officer turns up to investigate, the housing officer uses derogatory and insulting language in describing the boy's disability. Well, that is harassment, which is related to a relevant protected characteristic, in this case, the boy's disability. The mother can bring a claim. It doesn't need to be a claim brought in the boy's name. Section 15, however, remember that's discrimination arising from disability. In those circumstances, the claimant must be the person with the disability. So to give an example of this, in this case, Fiona is in a shop, she's in Tesco's, let's say, and her son has a meltdown. He starts screaming and shouting, he's lying on the floor, crying and banging his fists against the floor. And the manager of the shop asks them to leave because of his behaviour. Well, that is potentially discrimination because of something arising in consequence of his disability. But in those circumstances, the claimant must be the son, because it must be the person with the disability who brings the claim. Similarly, in relation to reasonable adjustments, and section 21(2) is what makes a failure to make reasonable adjustments discrimination. And again, that is discrimination against a disabled person. So in this circumstance, the son is refused a place on a school trip because the school are concerned about his behaviour, and they think that he will represent a health and safety risk on the school trip. Well, a reasonable adjustment might be, for example, to allocate a member of staff to take care of him, to use de-escalation strategies, for example, to prepare him in advance of the trip, to ensure that he knows what to expect and isn't overwhelmed, to allow him to wear ear defenders. There's all sorts of things which might be reasonable adjustments, which might avoid the need for him to not be taken on this school trip. But that would be discrimination against him, not against Fiona. And Fiona is not entitled to any reasonable adjustments being made in relation to her work, for example. Someone's at my door. Fiona is not entitled to any reasonable adjustments being made in relation to her work because of her son's disability. So that hopefully indicates why it's important who is disabled and how that might apply in different contexts. So I'm not going to go into this in a great detail, but I do want to pick up a few points on how you prove that there is this disability. And it's really, really important that this is addressed properly and fully, because it's the gateway to bringing a claim for disability discrimination. And it isn't enough to say, I have mobility problems, I have depression, I have any particular disorder, because the court isn't going to make assumptions. You need to prove every element of that test which Oliver set out. Now, that doesn't mean that it needs to be a well-established medical diagnosis. There will be plenty of situations where it is difficult to say what the cause of a person's difficulties are. That might be because there's confusion about what diagnosis should be made, or it might be because there isn't a clear physiological cause. Now, this isn't necessarily a problem in itself, but it does highlight the need to address all the elements of the test. Strictly speaking, expert evidence is not always required. However, in most cases, that will be the expectation of a court or a tribunal, that there will be expert evidence addressing this issue. One of the most important cases to deal with how you prove disability and what sort of evidence is required is JDL Piper. And it's this point that if a person has an adverse effect on their day-to-day activities, such that their day-to-day activities are impaired, in most cases, it will be a fair inference that an impairment has caused those impairments. I mean, it's an obvious thing to say. But it's important to recognise that it is perfectly legitimate to work backwards from the effect in order to find that there is an impairment. There is, as Oliver indicated, statutory guidance in relation to whether a person has a disability or not. But I raise this in the context of, well, what is the cause of the impairment? In most cases, this isn't an issue, but there are cases where it comes up, and it tends to come up in the same areas again and again and again. So at the most extreme or obvious example, a person, it doesn't matter whether a person has lung cancer because they've been smoking 60 a day for their whole life. It doesn't matter that a person has liver disease because they have been heavily drinking for the whole of their life. It's not for the court to start inquiring as to why a person has the impairments that they have. But where this gets a little bit more difficult is when we're looking at, for example, things like obesity. So a person who is obese might have a great difficulty with things like mobility and so on. The important point there is that it is not the obesity itself which is the impairment. It's the difficulties with mobility. It's the difficulty with breathing. And if once one approaches it in that way and one looks at the effect on day-to-day activities, then we can see that it's really not for the court to be judging why a person has those difficulties. Another issue where this comes up quite a lot is adult illiteracy. It will often be said by those who are defending claims for disability discrimination that an adult is illiterate, not because they have an impairment, but because they didn't pay attention at school, for example. Well, that's really, again, it's just not the right way of approaching it. Reading and writing is a day-to-day activity. If a person's ability to read and write is adversely affected, in most cases, and certainly unless another explanation offers itself, in most cases, it's going to be legitimate to assume that an impairment has caused that adverse effect. Proving disability, again, so substantial, we've already heard that this only means more than minor or trivial. I should say some of the case law which follows on from this would tend to indicate that that should be interpreted as minor and trivial, because there has been cases that have said that an effect can be minor and still not be trivial. And that in those cases, it might still be that a person doesn't have a disability. So it's perhaps slightly misleading, that provision. But we do have to disregard any medication or any aids that a person has. Essentially, when we are looking at whether or not a person has a disability, we're looking at sort of common sense, standard and widely accepted view of what it means to have a disability. So because a person is below average, for example, in their mathematical ability, that doesn't mean that they have a disability. The normal range of differences which people have is of course a range. And it's only once you are out, once the impact on day-to-day activities is outside of that range, that we can say that a person has a disability. The emphasis on what a person cannot do rather than what they can do. And this is going to make a lot of people, I think, quite uncomfortable when drafting their own witness statement, putting their own case together, because it does mean taking a very negative view of your own abilities or the ability of your son or daughter or other family member. So it can be quite uncomfortable, I think, to focus on those negative aspects, but that's the way that the case law is. And of course, it's quite right that a person might have difficulties in one area, and often will have difficulties in one area, while being extremely capable, if not exceedingly or exceptionally capable in other areas. In terms of day-to-day activities, and the reason why I raise these cases is that when one is putting together a witness statement or putting together a claim and setting out the effects that an impairment has on a person and why it is said that that amounts to a disability, we have to be really, really specific. So if we look at this Patterson case, so it's about comparing how an individual carries out the day-to-day activity compared with somebody who doesn't have that impairment. And that does lend itself to this sort of micro approach. And so I've given some examples as to how you might describe your own disability or the disability of, for example, your son or daughter. So mobility, not just saying I have difficulties with mobility, but what exactly are those problems? I walk slowly because I'm in pain. I find it difficult to manage stairs. I can't walk for too far. I need to sit down after a little while. It takes me longer to get places. Cooking, is it difficult to plan a meal? Is it difficult to handle pans and tin openers and so on? So you can see that I've given various different examples there, but what I'm really trying to highlight is this process of thinking through how you do things and explaining what the difficulties are, addressing that to those day-to-day activities so that you can really explain why it is that you have a disability rather than asking the court to assume that that's the case. So I've said already that the Equality Act only covers certain areas of activity. And these are goods and services. So this might include transport or your local swimming pool, public functions, for example, claiming benefits or the police, premises. So that's not only renting, but also estate agents, for example, or buying and selling property. Work, that includes agency workers and applicants for jobs, and education, and that includes not only school pupils, but further and higher education, for example. So there's lots of different areas of activity that are covered, but it doesn't cover relationships between private individuals. In most cases, in order to fit into one of these areas, you need to have a detriment in most cases. Now, that's not true of public functions. In public functions, those exercising a public function discriminate when they do anything which constitutes discrimination or another unlawful act. But in most cases, as I say, there needs to be some detriment. But this is really, really not a high threshold. And the important point here is that this includes a loss of choice. So, for example, if a school says, well, Molly is hard of hearing, and therefore we are not going to take her to the school play. We're not going to take her on this school trip to see a play because she won't enjoy it. But instead, we're going to put on some other activity for her to do in the school, and it's going to be great fun for her. And don't worry, this is going to be just as good. The point is, the court, or in that case, the tribunal, doesn't need to engage in a debate about which is better. Is it better to go on the school trip, or is it better to stay at the school and do the fun activity that the school are planning on putting on for Molly? That's irrelevant. The point is that Molly was entitled to have a choice about it. And actually, if she wanted to go on the school play, it wasn't for the school to say, well, she wouldn't enjoy it. So you can see that detriment is quite a low threshold. I'm not going to deal with this too much. But in terms of jurisdiction, in most cases, you'll be issuing a claim in the county court. And you'll be going through those three things that I said you need to have coincide in order to bring a claim. So that's the protected characteristic and why you say that you meet the criteria for having a protected characteristic, the unlawful act or discrimination that you rely on, and why you say that the way that you've been treated constitutes an unlawful act or discrimination, and the sphere of activity, which, as I say, in most cases will mean showing that there has been some detriment to you. As I say, most claims need to be brought in the county court. There are some exceptions. So, for example, schools cases brought by school pupils will be brought in the first tier tribunal that deals with special educational needs and disability. Employment and work cases will generally be brought in the employment tribunal. So there are these exceptions, but for the most part, you're talking about going to the county court. Remedies, the court has quite wide powers, or at least the county court has quite wide powers. These are a bit more limited in the tribunal system, and in particular, school pupils can't bring a claim for damages on the basis of disability discrimination, although they can in other contexts. But the county court has quite wide powers, and importantly, it can award damages, including damages for injury to feelings, and it can also make an injunction. And that means, I'll go back to that in a minute. It can also make an injunction. So that might mean, for example, an order that that your landlord makes a reasonable adjustment, or an order that you get offered a tenancy that you wanted to have, or that a shop apologizes to you. There are lots of different things that a court can order, and these are not particularly limited. Damages for injury to feelings, these are in three brackets, which are generally known by the name of the case which set this up. So that's Vento, and you will hear talk of the Vento bans. This is an evidence-based process. So it's not just about saying, I've been treated really, really badly, and therefore I should get £6,000 or £12,000 or however much it is. It is for you to explain how the discrimination has affected you. Did it make you feel like you were less worthy than someone else? Did it make you feel that you were being trivialized or demeaned or insulted? Did it make you, did it affect your self-esteem? Did it make you depressed? All of those things are things which are reflected in an award for injury to feelings. Aggravated damages are a way of giving compensation on top of the effect, on top of the compensatory award. So they are not compensatory. And they, for example, might be awarded where the person who is discriminated against you calls you a liar, says you're making it all up, says that you're making a mountain out of a molehill, bullies you throughout the court process. Those are all reasons why aggravated damages might be awarded. So that's the end of my bit. It was a whistle-stop tour, but still longer than I said it was going to be, of course. But hopefully now we'll be able to still address some questions. So I'm going to stop the share.
Thanks very much, Sarah. Shall I summarise some of the questions? I think some of the early questions you've actually answered, which has been really helpful. So someone has asked if a situation could be classed as indirect discrimination and also discrimination arising from disability. Would you bring both? Do you have to pick and mix? Can you argue both? How does that work?
I might take that one. So yes, that's definitely something where you can bring both. It's going to depend a lot on the facts of the case, whether one might be stronger than the other. So one of the things that can be an advantage about discrimination arising from disability is you just need to show that the person's been treated less favourably. For example, you don't need to show that there's a particular rule or practice. And sometimes that can be a problem in a case to show there's a rule or practice. So for that reason, you might say it's better to use discrimination arising from disability. So it's really about the facts of your case, but there's nothing to stop you from arguing both, where both apply and just putting on the pressure, basically.
I would say in most cases, it's going to be a lot easier to prove discrimination arising from disability, because you don't need to prove any group disadvantage. So you don't need any statistics or anything like that. You don't need to make any comparison. So it's a lot more straightforward.
Thank you. Someone else has asked about whether the Equality Act applies to prisons. Sarah?
Yeah, absolutely. Absolutely. When you are imprisoned, they are exercising a public function in relation to you. So that falls under Part 3 of the Equality Act. So yes, absolutely it applies. I mean, it's fair to say that in contexts like a prison context, you are that proportionality exercise might be slightly skewed against a prisoner, as opposed to a public body which has got to deal with an awful lot of different things, and whose primary purpose, of course, is not the care and consideration of inmates. But it absolutely applies.
Thanks. And maybe the last question, very interesting question about a gym, and if there's a member of the gym who's autistic and who has sensory issues and can't cope very well with loud music, and they want to attend classes where the music is blaring in people's faces, and not so interested in yoga and other sort of meditation where there's different type of music, what can be done in that case? I mean, first of all, does the Equality Act apply to a gym?
Yes.
Sarah?
Yes. Absolutely, it's a service. In fact, I did a gym case quite recently. So yes, absolutely, it applies. First of all, there will be an anticipatory duty because it's a service provision, and a gym should anticipate that there will be people with sensory issues and autism who won't want loud music, and so I would expect that in accordance with that anticipatory duty, a gym might, for example, have occasional silent sessions or quiet sessions, which are designed for people with autism. So you would expect there to be something which is kind of built into the program that deals with that, especially if it's a larger gym. A smaller gym might feel that they can't manage that, but a large gym, you would expect them perhaps to have something that is going to deal with that.
I think about movies. Some cinemas run, for example, screenings of films that have a different sound level precisely to deal with these kind of needs for people. And again, I think whether or not it's something that's proportionate for the person to do, as Sarah says, depends if it's a big gym or a small gym. It's going to be factually specific, but it's certainly something they should be thinking about. Sorry to cut in, Sarah.
No, I was just going to explain something which isn't obvious on the face of the Equality Act, is that when you're looking at the provision of services or public functions, there are essentially two limbs to the duty to make reasonable adjustments. There's the anticipatory limb, and there is also the limb that arises once the service provider is on notice that there is a relevant disability. So what we were just talking about relates to that first limb, but you might also write to the gym and say, I have autism, I have difficulties with this, I would love to come to your gym, I'd love to come to a session, but at the moment there's nothing suitable for me, can you put something on? And that's a different responsibility that they have. And I mean, and again, that's going to depend on the facts of the case and how large a gym it is, whether they've got any other takers for a session like that. They might choose to do a survey, for example, and find out whether there is a need or a desire to put on a session like that. But they are two separate limbs, although you wouldn't know that if you were just reading the Act.
Brilliant. Well, there are some other questions. I'm sorry that we have not been able to go through everything. You've got, or you can easily look up our email addresses. And we said that we would stick to time. So it's now 1 minute past 4. So we're going to finish now. We hope that it's been useful. We'll make the slides, I think we'll make the slides available. And there's going to be a recording, obviously, as well. And so we'd like to thank the very many people who have joined us. And again, if we can answer any further questions, you can contact us via our clerks. And if we're able to answer any questions which don't relate to individual cases, then we'd be more than happy to take a look at those. But thank you very much for joining us. And thank you very much, Sarah and Alice, for your fascinating presentations. Thank you and goodbye.
Thank you.